The comment that I have for you, Mr. Anderson, is I understand you have a young daughter and you want to be there for her. You want to support her in any way you can. Just keep in mind that if you come back before me and you have violated one of my orders or you otherwise break the law, you will not be able to use her as an excuse. You are on notice. You know you have a daughter. You know you need to be there for her. So I'm not going to listen and say, well, Judge, you can't send me to jail or prison because I got this daughter. Well, you better think about that now, because moving forward, you can't simply throw that up in my face and say, well, I have a daughter. No, it doesn't work that way. You're on notice. I'm aware you have a daughter. I'm aware you're trying to get your families to stick together. But if you're going to resort to violence or you otherwise break the law, just keep in mind that will not be an excuse.
Judge, on behalf of the state, my understanding is that Mr. Anderson has 3 days jail time credit. We've received a recommendation from probation. I will defer to probation on this, but I do want to put on the record I have a lot of concerns about this case. The underlying facts are very concerning. I would ask that should the court place him on community control, that a very tight leash be kept on him, and that he be ordered into the appropriate treatment and make sure that he engages, because I do have concerns about the victim's safety in this matter. I don't know, is she here? She wants to make a statement? Okay, so apparently Ms. Thompson is here and would like to address the court.
Brandy Anderson, also known as Thompson. I do ask the court to please allow for probation. We have been together living in the same household, and our very beautiful little girl back here with no concern. I do not have concerns about my safety or the safety of our daughter. I just ask that you please allow him to be able to be on probation, to be able to provide for his family and to help take care of his daughter and raise her. Thank you.
Ms. Tranter, is there anything else?
Nothing further, Your Honor.
Anything from probation?
Nothing further, Your Honor.
All right. Mr. Brewer?
Judge, as you're aware, I filed a memorandum in support of sentencing, and we are asking for community control. Only to touch on a little bit, I think Ms. Anderson just touched on it, but Mr. Anderson does have a full-time job. He has maintained full-time employment throughout this entire process. He does provide the health insurance for their newborn. Through this process, when the protection order was released back in November or so, they lived together for this long, and it's not to say they never had any arguments, but none of them have been violent. They've gone through counseling. He's helped take Brandy to her doctor's appointments. He was there for the birth of the baby, so they've been together. They've been through a lot. There were a lot of stressors back in during the summer, and that came to a head. But I think they've sought counseling between them, and they're doing what they can to resolve those particular issues, and we're just asking that you consider him for community control.
Mr. Anderson, is there anything you'd like to say?
I'd just like to say I'm really sorry that any of this ever happened. I've never had a history of violence at all. Me and my wife, we just got married, found out that we weren't married, found out that she was pregnant, so we had to get married again to make it legal. We moved into a new house. It was just under a lot of stress. We got into an argument. I should have just walked out the door. We both did things I'm not happy about. I love my daughter. I've made a lot of changes in my life to get where I'm at today. If you talked to me 10 years ago, I'm so much better than what I used to be. If you give me a chance.
The court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. The court has reviewed the pre-sentence investigation together with the memorandum filed on behalf of the defendant by Mr. Brewer and the attachments thereto. Mr. Anderson, I am going to find today that you're amenable to community control, so I'm going to place you into community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. I am ordering you to refrain from the use of any drugs, alcohol, or marijuana. Do you understand?
Yes, sir.
You're ordered to successfully complete mental health counseling. You will complete the batterers intervention program. and you will complete the thinking for a change course. It looks like you have 3 days jail time credit. The court finds that you have the present and future ability to pay the cost of prosecution. So although I'm not going to fine you, I will assess the court costs against you. If you don't pay those, I can order you to do community service of up to 40 hours per month until you pay that in full, or you make appropriate arrangements to get those costs paid off. The comment that I have for you, Mr. Anderson, is I understand you have a young daughter and you want to be there for her. You want to support her in any way you can. Just keep in mind that if you come back before me and you have violated one of my orders or you otherwise break the law, you will not be able to use her as an excuse. You are on notice. You know you have a daughter. You know you need to be there for her. So I'm not going to listen and say, well, Judge, you can't send me to jail or prison because I got this daughter. Well, you better think about that now, because moving forward, you can't simply throw that up in my face and say, well, I have a daughter. No, doesn't work that way. You're on notice. I'm aware you have a daughter. I'm aware you're trying to get your families to stick together. But if you're going to resort to violence or you otherwise break the law, just keep in mind that will not be an excuse for you. Do you understand me?
Yes, Your Honor.
There is no contact order issued at the request of the victim in the case. Is that correct, Ms. Tranter?
Yes, Your Honor.
Ms. Tranter, is there anything else?
Nothing further.
Mr. Brewer?
No, sir. Thank you,
All
Your
right.
Honor.
Good luck to you.
Thank you, Your Honor.
Mr. Anderson, there's been a allegation you have violated your terms and conditions of community control. Can I please have a reading from the probation department?
General condition number 1, on May 24th, 26, the defendant committed the offense of domestic violence F3 and was charged in Lebanon Municipal Court, reference case number CRA 2600270.
Sir, did you hear those allegations as they were read out loud?
Yes, I do, Your Honor. They are allegations.
And at this point, the court finds that there's probable cause that you have violated your terms and conditions of community control, so we'll set this over in front of Judge Teep. Do you have the means or ability to retain counsel, or do you need a court-appointed attorney?
I have a lawyer. Yes, I do.
Who is your attorney?
David Brewer.
Okay. Was he appointed or retained?
I paid for him.
Okay, and you retained him for this PV as well? Perfect.
All
We-
of it.
We will get this set with Mr. Brewer. While this is pending, anything from the state with regards to bail?
We would ask that he be held at this time pending a hearing in front of Judge Teep. I'm not sure what his bond is in the lower court. He has a $100,000 bond with EMHA in the lower court. This is he has not been on probation that long. We would ask that he be held.
Mr. Anderson, anything you would like to know with regards to bail, only keeping in mind you have the case pending, so you don't want to go into the
Yes.
facts or anything?
So I have been in excellent stance with all probation throughout pretrial, when I was on house arrest, all the things, made it to every appointment, passed every drug test. All I'm asking is that with these allegations, I'm gonna take this to trial. If I could get out on bail, go back on house arrest, I have a house I can go to that's nowhere near this alleged victim. I'm in the process of getting a divorce also. I filed. I think she's just upset, a couple of other things, but I'm willing to post bail and abide by everything needed.
I'm trying to look right now. I'm not aware of whether he's posted bond in that lower court yet.
Well, I had a holder, so I didn't put any money down because I didn't want to lose the cash.
If the court is inclined to release him, we don't believe an OR in this case. I mean, for the protection of the public and his ability to reappear, he certainly has consequences he is facing, potentially.
Like I said, to go back on the monitor or whatever. I'm just trying to get back to work and then have my right to go to trial.
Where are you working right now?
Valco Melton, I've been there for almost 5 years. It's a machine shop. It was under Officer Edwards the whole time I was on ankle monitor. Got moved to Conroy And
The
then it got
case
moved.
takes a serious turn. The judge acknowledges the pending domestic violence charge and the complexity of the situation. Despite Anderson's request for bail and electronic monitoring, the court orders him to remain in custody until the matter can be scheduled before another judge. His freedom is suddenly on hold.
And then got moved to Robert Henry. And every one of them, I've passed everything, done everything I needed to do.
There is also a domestic violence CPO pending.
Just due to the complexity of having a high-level felony, understanding you're presumed innocent of that, coming through and that being the potential violation of community control, I'm going to let Judge Teep take a look at this, so I will say you're to remain in jail until he can get this matter set. They will set this for a final hearing, which will likely be kicked out until resolution of your other actual F3 case. But that way, Mr. Brewer can get in front of the judge and discuss bond with him. So we will get this set as soon as possible with Mr. Brewer.
Do you do when?
Hopefully next week sometime. I would have to ask Judge Teep's assignment commissioner. Usually they set 1 to 2 weeks, aiming for 1 week, if not less.
So there's no bond?
Not right now.
Oh.
All right, best of luck to you, sir.
Thank you.
25 CR 42912, 26 CR 43684, the State of Ohio versus Kenneth Anderson. Okay, Mr. Anderson, with regard to the 26 case number 43684, they're telling me that you're going to change your plea to guilty. Before we get to that, I'm required to go over some things with you. Okay, sir? How old are you?
35.
How far did you go in school?
I graduated high school, 3.8 GPA, and then I went to trade school, finished that with a 4.2.
Are you able to read and write?
Yes, sir.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you other than this recommendation that the attorneys are making to me?
No,
This
Your Honor.
document says you're entering a plea of guilty to 1 count of domestic violence. As a felony of the 4th degree, that carries a maximum penalty of 18 months in prison and a maximum fine of $5,000. Do you understand the maximum penalty?
Yes, Your Honor.
Ms. Tranter?
Your Honor, this occurred May 24th, 2026, Warren County, State of Ohio. On that date, Kenneth Anderson did knowingly cause or attempt to cause physical harm to a family or household member having previously been convicted of domestic violence.
Mr. Brewer, anything on those facts?
No, sir, Your Honor.
Mr. Anderson, did you hear the statement that she read?
I did.
Do you admit that what she stated is true?
Yes,
And again, you understand all the rights you're giving up when you enter plea of guilty.
I did.
What is your plea?
Yes.
The court will make a finding that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Under case number 25CR 42912, the probation violation, Mr. Brewer, does your client wish to have a hearing on that?
No, sir, he will admit to the violation.
All right, Mr. Anderson, on that charge, on that case, you understand you're entitled to have a hearing,
I do.
and you wish to waive that hearing and admit to the violation.
Yes, sir.
All right, is there anything you want to say before I sentence you on the new case and sanction you on the other case?
No, Your Honor.
All right. Under case number 25CR 42912, the court finds that you are no longer amenable to community control and that prison is now necessary to fulfill the purposes and principles of sentencing, including punishment, deterrence, and protection of the public due to your failure to respond to the previous community control sanctions. So on that case, the court is going to order you to serve 6 months in prison. You have 84 days jail time credit. We will assign all 84 days to that first case. Under case number 42912, the court's going to order you to serve, the court's going to find that you are not amenable to community control and that prison is necessary to fulfill the purposes and principles of sentencing. The court specifically finds that this is basically the same offense that you are already on supervision for and you failed to comply with the community control sanctions. So the court will order you to serve 12 months in prison on the new case, that to be served consecutive to the 6 months under 42912. I find that the consecutive sentence is necessary to punish this defendant. It is not disproportionate to the conduct or danger posed by the defendant, and the defendant was already on supervision at the time he committed the second offense. So it's 18 months total, 84 days jail time credit. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Is there anything else?
No, sir.
Mr. Brewer?
No, sir.
Good luck to you, sir.
Thank you, Your Honor.
Thank you.
Cases had wished to make a statement to the court prior to sentencing. Is that fair?
Yes.
and the court was unaware of your presence in the courtroom. So I apologize. What would you like me to know?
Will acknowledge that I was not readily available for Ms. Kennard. Unfortunately, I do work a full-time job and do have 3 children to take care of. It seems that our schedules just didn't necessarily line up, and for that I do apologize. There were several voicemails left to her. I will acknowledge in this case that it is not as cut and dry as everyone believes or is. However, 7 days leading up to this case, our very small child, less than 6 months old, was hospitalized near death. They honestly was, I performed life-saving measures on our daughter in my kitchen on the counter. And unfortunately, this was the after effects of what happened. And I will stand here and tell you that if you ask me to stand here and swear and be darned by everything that was in that report, I can't actually do that. I am struggling with postpartum and PTSD, and I'm medicated and working with my physician, and I have been called out several times on other things that occurred that day that have not actually been factual. I believed that they were, but it has later been proved that they were not in fact factual. I can't stand here and make him make any decision, do anything any differently. We've not even been allowed to communicate other than about our daughter. I will acknowledge that my part in this is not pretty either. I am struggling just as much as I'm sure he is. And I'm asking that we at least acknowledge the fact that you had 2 parents who were sleep deprived in a hospital for 6 days, literally the day before all of this, with the thought that their daughter wasn't even going to make it for the 3rd time in her only 6 months of life. This wasn't a case of I'm going to be angry, I'm going to be mad. It's everyone is exhausted and mentally struggling. And that we potentially just take some of that into account. And I will take my ownership that I'm not 1,000% sure as to what happened that day. I believed when I made the report with the police that I knew, but I'm not sure.
Anything else?
No, Your Honor.
I hope you understand from your perspective the court's role in this. You understand that when even at this stage of the proceeding, were you here when Ms. Tranter read the statement of facts onto the record?
Yes.
Are you saying that you're not sure that they're factual?
I'm not 1,000% sure that they're factual.
Well, you understand that I don't know because I wasn't there.
Correct.
Okay.
Correct.
So what I rely upon is the defendant, Mr. Anderson, admitting that those facts, as Ms. Tranter stated them, was true. So again, he was on supervision with me, community control for I believe it was it was an F4 domestic violence too. He was on community control at the time this offense happened. He has admitted in open court, after waiving his constitutional rights, that that statement was factual. So again, I don't know what you expect me to do. They have come to me with an agreed recommended sentence.
I understand.
I have all but 2 times in my 10 years on the bench have followed the recommendation. And every time I haven't followed the recommendations, it's because the sentence I believe that was being recommended was too light. So I've always gone the other way and have given a heavier sentence. I think one was Ms. Tranter's case, but that's my philosophy. So is there anything else you're asking of the court today?
In lieu of jail time, is there any ability to provide any mental health services?
Well, I haven't sentenced him to jail time. I sentenced him to prison time. So he's not even going to be in our local facility. He's going to be sent to the Department of Corrections. What he does there is between him and the Department of Corrections. I don't control them. I can't even tell you where he's going to be housed. That's just not, once I sentence him, I kind of lose jurisdiction as far as where they send him. I think he'll go to Orient first, and then from there, based upon his risk level, they will send him to a specific facility. There, he can engage and sign up for whatever courses that the Department of Corrections has available to him. But Is there anything else you'd like me to answer?
No, Your Honor. Thank you very much for your time.
All right, thank you. In light of this, is there anything else, Ms. Tranter, for the record that you want, we need to make a record of this?
Your Honor, there's nothing from our perspective, no.
Ms. Kennard, as the victim advocate, victim
I just want to
representative?
clear up that I had reached out to her several times. The only time I've ever had successful contact with her was when at grand jury, and then here when she came to drop the no contact order. Unless she left voicemails for me today while I've been in trial,
I did
on
as
a-
well
on
as
a-
Friday evening.
I have no voicemails from Friday evening. I do have missed voicemails today, because I've been in trial. Otherwise, I've received no voicemails.
Okay, all right, thank you. Mr. Brewer, is there anything on behalf of the defendant?
No, sir.
Okay, anything else from the defendant?